FlySafair, the country's low-cost airline, an urgent interdict that scraps the January 2026 deadline for it to make sure that it fixes its foreign ownership structure. This deadline was imposed by the International Air Services Licensing Council. Now, the Air Services Licensing Council threatened the airline with sanctions in late 2024, and these included a suspension or a cancellation of its license. FlySafair was given 12 months to resolve its ownership structure. And for more on this, we're joined on the line by Aviation Analyst Leitch. A very good afternoon to you, Guy. Good to have you with us. Welcome.
Yeah, hi. Nice to be with you too.
Perhaps let's start off with an understanding of what the impasse is. Could you take us through the current ownership structure of FlySafair and what the Licensing Council wanted it to rectify?
Yeah, well, it's quite a convoluted little story. So I need to take listeners back to 2014 when FlySafair was originally founded. And it was founded essentially by the holding company of the company that was originally called Safair. And Safair is held by an Irish company, Air Services, the aircraft leasing company. And at the time, Comair objected to the fact that FlySafair was more than 50% owned, in fact 75% owned by an offshore company, because the law says that 75% of an airline, South African airline, has to be owned by South Africans. So there was if you remember, FlySafair didn't in fact get off the ground for about another 8 or 9 months while the ownership structure was changed, and they created a trust for the local entities, and that was acceptable to the Air Services Licensing Council, and so they launched. But then in 2019 or thereabouts, it was discovered that actually the ownership structure had been quietly changed, and now the Irish leasing company was now effectively once again the majority shareholder, or at least that was discovered in terms of the formal reporting, the annual reports by the Irish leasing company. And there were obviously complaints from competitors, notably from Airlink and from Lift, which is Global Airways. And this matter has been grinding through the courts pretty much since then. And it's not an easy thing to decide upon, which is why initially the Air Services Licensing Council gave them a year to sort it out, and now they've effectively given pretty much an open extension to continue to sort it out.
So were there any repercussions for this quote-unquote silent change?
No. There haven't been any repercussions yet for FlySafair, which must, I suppose, really irritate the competitors. But as I said, the matter is complex or convoluted. It relates around very elaborate legal constructs, such as the beneficial ownership of trusts, and what exactly is a natural person. Is it a warm flesh and blood person? And if so, what about where do they actually reside? Do they have to be South African citizens, or do they have to be residents of South Africa? These are all things that are being argued in the courts. I think one of the benefits of this whole exercise will be that there will be a lot more certainty or clarity on the way or on the shareholding requirements of airlines. But for now, it was clear that they weren't going to get a clear decision by the deadline at the end of this year. So the court has effectively granted an indefinite extension, which I think goes to show sympathy for the fact that FlySafair is actually properly campaigning the issue, at least through all the legal mechanisms.
This level of ambiguity or perceived ambiguity, is there a history or precedence of this? Because this is not the first airline to be granted a license, and these are prerequisites that have been there from the beginning.
Well, yeah, look, it's the first airline to have had its foreign shareholding questioned, and that is why these issues are essentially novel, or if you like, precedent setting. As I said, the issue is, yeah, sure, you can have a trust that's domiciled in South Africa, but what happens if the trustees are in fact foreigners? Does that meet the law or is not? And these are issues that are being tested for the first time in a court. I think it's worthwhile, if I may jump to perhaps or anticipate another question. Well, does it make a difference? The complainants, so FlySafair's competitors, argue that it does because they say that a foreign shareholding gives access to cheaper capital, and capital is one of the single most important inputs into an airline. It's made it possible, for instance, for Airlink to acquire 10 brand new aircraft on leases. And it's one of the biggest constraints that SAA currently faces is the lack of capitalization. So the competitors argue with considerable conviction that FlySafair's foreign ownership gives them an unfair advantage.
And do we know what the airline has done to date to try and rectify the structure and even, I guess, the interpretations of the law and the clauses therein as per International Air Services Licensing Council directive?
Well, the airline hasn't, in fact, done anything other than ask the ASLC, that's the Air Services Licensing Council, for a clarification as to what they actually mean by a South African resident or by offshore ownership and what is the beneficial ownership of trusts. All of those questions, they've been asked, and they said, look, we will comply as long as you tell us what the actual the goalposts are, if you like, what the requirements actually are. If you give us clarity on what those are, then we will comply. But until we know exactly what those requirements are, because the Act is not very clear, then we're just going to continue on as we are at the moment.
So Guy, why exactly did the court grant this interdict? And as you say, it's indefinite. By January 2026, it was supposed to have been resolved. But now, obviously, it extends that period, even of discontent, for the competitors.
My understanding is that the court granted the interdict or gave the extension in time because the matter is, in fact, I don't want to use the word sub judice because it gets used and abused so much, but the fact is the matter is in the hands of the court already. So the courts are effectively just giving themselves more time to try and resolve the issues.
Thank you very much, Guy Leitch, putting that into perspective for us. Certainly we'll continue watching this very closely. As you said, it is going to be a precedent-serving ruling, whatever the outcome may be as far as foreign ownership and what actually constitutes foreign ownership in the interpretation of that law. Aviation Analyst Guy Leitch, always a pleasure. Thank you, sir.
My pleasure.
Thank you. Guy Leitch takes us to 22 minutes after